of the T.C. Williams School of Law, I extend a warm welcome to the deans, our faculty and staff, to all of our students and friends. I share the stage today with a very distinguished gentleman, our guest speaker, Judge Robert R. Merhige, Jr., who will speak to all of us on professionalism in law. Judge Merhige is a United States District Court judge for the Eastern District of Virginia. He received his bachelor degree from High Point College, and he graduated from our T.C. Williams School of Law in 1942. He was appointed to the district court by President Johnson in 1967, so he recently celebrated his 20th year on the federal bench. And even though he officially took senior status last November, Judge Merhige does not live the life of a retired or semi-retired man. He is presently involved in the A.H. Robbins bankruptcy reorganization case. He continues to perform all of his regular duties. He has been involved in many widely publicized as well as controversial cases. He ordered state prison officials to extend due process to convicts in 1971. He ruled that pregnant women were entitled to maternity leave benefits. He helped order certain Watergate tapes to be made public. And he levied the largest pollution fine against Allied Chemical Company for the Keepone pesticide pollution of the James River in 1976. During the 1970s, Judge Merhige also ruled on over 40 desegregation cases, including ordering crosstown busing for Richmond school desegregation. And even though he does not enjoy any controversies that upset his community, he was quoted recently by the Richmond papers that he would rather see everyone upset than to see anyone's constitutional rights violated. When I went to ask Judge Merhige this summer if he could possibly speak to our faculty and students, we started to discuss a topic for his address to you. He was already sure, however, of his topic. In fact, he knew exactly what he wanted to talk with us about. He knew that he wanted to talk about professionalism in law. His calendar was indeed full through at least the end of the year, and even though he was obligated already to speak at functions throughout the United States, he worked with me to secure an available time for him to come out to our school. We are indeed fortunate to have him here today. Would you please join me in extending a warm welcome to Judge Robert R. Merhige, Jr.
Thank you very much. I suggested to one of the professors that you all obviously getting credit for attending. Let me relieve any concern you might have about this volume that I have here. It's really a security blanket. I will make reference to it, may even read from it. But I found out a long time ago that judges have it just goes with the territory. We are frequently quoted out of context. And it seems to me that I'm fairly safe if I write it out, but I never stick to it, so people can quote me out of context. What's even worse is might quote me in context, but I take this as security. And now, one of the reasons, and some of you may have heard this story, and it's a true story, some few years ago, and I must confess that time doesn't mean much to me anymore. I told somebody after I passed 50, I seem to spend half of my time trying to remember names and the other half looking for a John. I really don't know much about time. When I say a year ago, it might have been 5 years ago. It could have been yesterday. But some years ago, I was trying a bank robbery case, which was nothing unusual. In those days, we don't have you don't handle as many. I don't know whether they quit robbing banks or whether they're all being turned over to the state. But in any event, I had this one. And the man looked like this chap in the TV series The Rockford Files. James Garner, that was it. And he sat there with his counsel, very stoic. He never seemed to change his expression. And everybody came in, every witness said, "That's the man that did it. I know, because he looks just like James Garner." His lawyer told me later that he leaned over and said, "I think Garner may have pulled his job." The fact of the matter was, there wasn't any doubt who pulled the job. And the evidence went like this. He had gone into the bank and he'd taken out a gun and said, "This is a stick-up." And the teller laughed at him, so to convince her, he shot a bullet into the ceiling. He said, "I mean it, now move." So she gave him the money, including bait money. And before he got out of the bank, the bait money exploded. He got out of the bank, his getaway car wouldn't start. I mean, everything went wrong for this poor guy. And they got him. Well, I am not concerned, really, and I'm serious for a moment, about people who I may personally think are guilty who get acquitted if they do it by the rules. Because I don't think a rapist, for example, or a bank robber, or any person who would commit a crime is worthy of sacrificing the things we've worked so hard for in our constitutional rights. And one constitutional right one has is to remain silent. And there's a presumption of innocence, and this fellow exercised that. And I must say, I can't say that I give credit, but it's in the back of my mind when I get around to sentencing somebody, you didn't get up and perjure yourself. Because to me, perjury is the worst offense imaginable. It will ruin our system if we don't do something about it. But that's another story. That's not even part of my talk. What I wanted to tell you about was when I got ready to sentence this fellow, I saw that he was an escapee from Atlanta, and he was serving 60 years then. So I said to him, "Look, I'm having a hard time deciding what to do with you. You've been found guilty of bank robbery." I said, "But you're already serving 60 years, and you've been in a number of bank robberies. You've also been in a number of escapes. As a matter of fact, he was on escape at the time he got caught." I said, "I sort of feel like the judge who sentenced the man to 100 years, and the man said, 'I won't live that long.' You know, it's an old one. And the judge said, 'Well, do the best you can.'" I didn't want to say do the best you can, so I said, I'm willing to negotiate with you. I said, "How about giving me your word that you will not commit any more bank robberies if you ever get out?" And he said, "Oh, I'm sorry, Judge, but I can't promise that." I said, "Well, you know, you're not very good at it, as evidenced by the fact that you've been caught 2 or 3 times." He said, "I'm sorry, I can't." Dedicated to his profession, I guess. I said, "Well, how about giving me your word you won't try to escape?" Now, I must admit, you've been a little bit more successful there than you have in bank robbery. I said, "But if you do it, the marshal is apt to get hurt, or you're apt to get hurt, and I don't want that to happen." And he was just making it so difficult for me. He said, "I'm sorry, Judge, I can't make any promises." And as an aside, I must say the marshal had told me when they transferred him, they went in convoy because he had a reputation for having friends all over the country that they thought were going to break him loose. So finally I was desperate. I said, "Well, how about promise me you won't try to escape from my marshals, my people?" He said, "I'm sorry, Judge, I just can't make that promise." So I said, "Well, all right, I'll do what I have to do." And I then made a big mistake. I said, "You know, except for the fact that you rob banks, and I don't, you're really my kind of a guy." And I went on and sentenced him. Well, some of you know the story, I'm sure. The next morning, as you know, I'm the darling of the local papers. Have been for 20 years. There was this sub-headline, "Merritt says bank robber is kind of a guy." So I bring my little pad with the hopes that I can refer to that. But that's kind of silly because Cheryl, who's my wife, says that the difficulty with my speeches are that I have this terrible tendency to get off the subject and I compound the thing by getting back on. And she's right, I do get off the subject. One more little story, and then I will get to the few words that I have to say. Your chairlady mentioned the case. She didn't mention it by name, but she was talking about Gilbert versus General Electric when she spoke of the pregnancy issue. Kind of scares me. I was affirmed by the Fourth Circuit on that. I held it was sex discrimination. The GE would pay in their health benefits for a man to have a vasectomy or even whatever they do to have a hair transplant. But pregnant women, they got no benefits at all. I must say, it was ultimately, my decision was ultimately reversed by the Supreme Court of the United States. Chief Justice, as I understood the opinion, said it had nothing to do with sex. But while I was sort of enjoying, I don't keep score, but I knew that my view had prevailed in the Fourth Circuit, and I was invited to speak to the ladies' bar. And the lady was kind enough to introduce me as a man who was responsible for the welfare of like 7,700 pregnant women. So that's a slight exaggeration. 6,999. Well, let me talk about what I really want to say. Cicero's perception of lawyers is expressed in his description of a compatriot, and I quote, "As so just and virtuous a man that he seems to be a lawyer by nature rather than by training." I'm afraid that perception has gone with Cicero's times. We, I must say, in the legal profession are, in my opinion, worthy recipients of the monopoly that we have, and we do have a monopoly. In the last 100 years, we've become organized. We've created our own rules of professional responsibility, and under the auspices of various state rules, have sometimes enforced them. We have managed to preclude those who are not lawyers from performing many activities which we have reserved for ourselves. Now, as justification for this, we and those who were ahead of us instilled in the minds of the public the belief that we were a profession worthy of the public faith. We encouraged people to believe that they could and should entrust their business and their liberties to us as trained professionals whose selfless devotion was to them. Now, in exchange for that, we were required to go from simply calling ourselves lawyers to reading law, to formal legal education, to exhibiting our competence in the law by virtue of bar exams, or in some instances, graduation from particular schools. Those of you who have just started law school, or even those of you in the third year, would, I think, be happy. Well, it doesn't make any difference, but I think you would agree with me. I am opposed to bar exams and have expressed that view for ever since I passed. But seriously, I think bar exams are grossly unfair. I've seen some of the, well, I passed it, for example, at the end of my second year without benefit of the coach class, because it was $25. I think it's a little more expensive now. And I looked through, no question about it, and there's some very, very bright people who fail the bar. I think the best people to decide whether you're qualified to go out as a lawyer are your professors. And if you graduate and take required courses, I think that's the way it ought to be. But that's another subject, because there isn't anything I can do about it, and they're not going to do away with the bar exam in Virginia for any time in the near future. It's not surprising, if you think about it, that we, members of the bar, attained a high level of prestige. After all, we belong to a recognized traditional profession, and through our training were, and we are, able to assert great influence on those governmental entities and the shakers and doers who control the enactment of rules, regulations, and laws which created a protective shield for the legal profession. It, of course, was not a one-way street. Those very rules, regulations, and laws were enacted, at least theoretically, to protect society as well. We were, and still are, considered to be a necessary and prestigious group of men and women who, for the most part, have fulfilled the trust and obligation of our profession to render assistance to those who entrust us with their property, their liberty, and in too many instances, their very life. Regrettably, what was once a universal perception of the bar and our profession is no longer so. Now, I hesitated about saying that to those of you who are law students. I hope you are amongst the lucky ones, as I was. I never wanted to be anything but a lawyer. And I guess it's lucky because I cannot imagine that I could have ever been anything but a lawyer. They almost burned the high school down to get me out. I was a terrible student. College, I wasn't much better, but it was easier. You didn't have to study. I mean, there was basketball and football and girls and music and what have you, and I was a C and D, occasional B maybe. But when I came to law school, the excitement of the study of law was just magnetic to me. And I am so grateful to my God that he made me a lawyer. And I hope those of you who are in law school now feel the same way about your study. It's not a grind, it's exciting, and it's exciting because it deals with people. And people are exciting. People are what make the world. But that, I didn't really want to come and talk about my feelings of the law, but anybody who knows me more than 24 hours knows how I feel about it. And I'm disturbed as to what's been happening to it. And I'm going to hope that people like you coming along, and some of the, I have no hope for some of our bar, but I have hope for a great majority of our bar that they'll get back to what it was like when I started, for example, when it was a sense of pride, a sense of giving. And I'm afraid that that has dissipated greatly in the last 15 or 20 years. As I've indicated, my life has been entwined with the law. My role as a member of the legal profession has been one of fulfillment, in part because of the opportunities it has given me to be of public service. Now I'm just, and I do digress, and I take too much time. Would you blow a whistle or something? Ask for a recess. So somebody out there do that. And I guess I mentioned this somewhere along the way. It's the amazing thing about our profession. And I feel sorry, as you may imagine, for anybody in the world that has to do something else to make a living. Oh, look at these guys that go up and or nuclear physicists, how dull. Or neurosurgeons, and that sort of thing. You know, we're probably the only profession, at least that segment of our profession who are trial lawyers, who are told on a daily basis whether they have succeeded or failed. And they're told either by somebody in a black robe or they're told by a jury. And it takes special people, I think, to be lawyers and to give of themselves. But the amazing thing about it is when you do, the rewards are tremendous. And they're not just the reward of having served. There isn't any thrill, with the possible exception of the birth of your first child, there isn't any thrill in the world to match a verdict from the jury in your first case. There simply isn't any, but you can make a living, and there isn't anything un-American about that. And you can even get rich, if that's what you want. The money just comes if you do your job, and if you do it well. Unfortunately, there are those amongst us who can't wait. You know, well, I think it was Georgetown about a time again, a few months ago. I was addressing a law student body, And before I went up, I asked my law clerks the question, what is our profession? The answer, I'm happy to say, while it was mixed, each included the component of public service. Dean Pound defined the legal profession well when he said, the term refers to a group pursuing a learned art as a common calling in the spirit of public service, no less a public service because it may incidentally be a means of livelihood. Pursuit of the learned art in the spirit of public service is the primary purpose. Now, before I trespass further on either your hospitality or your time, I would hasten to remind you that I have been on the bench for slightly over 20 years. I realize, of course, that great changes have occurred in the practice of law. The remoteness of a judge from the daily functions of a busy law office perhaps qualifies me only as an interested and concerned observer. Still, as Yogi Berra so succinctly put it, one can observe a lot just by watching. I'm conscious as well that my present work is both different and much less burdensome than the work of a present-day lawyer. Oh, being a judge is a snap, if you're going to be concerned about work, to that of a lawyer. A lawyer they work much harder than I do. They have to make more decisions than a judge does. And they just have that to decide them. I can have a coughing spell and take a recess and go back and think about anything I want to think. But if a lawyer if there's something objectionable, he's got to decide, one, is it objectionable, and two, do I want to object to it? They have to be concerned about time. If I'm late, I'm rude, and I try not to be late. If a lawyer's late, he's concerned that some robot in a black robe is going to take it out on his client. No, the pressures are incredible, but they're enjoyable pressures. As a lawyer, I remember them. I remember people calling at dinner time, and invariably was, I'm sorry to interrupt your dinner, but I knew I could catch you then. Well, they and a dozen others knew they could catch me. But it was worthwhile, and I hope some of you will feel the same way after you've been out. The first day you should start feeling that way. I realize, of course, that my views, my observations are influenced by the fact that while I spent 22 years as a trial lawyer, it was a different era. I know, however, that some things have not changed. I'm sure that Murphy's Law, that everything that can go wrong will go wrong, is still in effect, as is the truth contained in O'Toole's comment to Murphy's Law, that is, that Murphy is an optimist. Lawyers have things go wrong every day. I must make one more, it says prefatory, I'm almost hesitant to use that word because it makes it sound like I'm not almost through, and you all have been here already, much too long, I suspect. But I'm going to say what I want to say anyway, and if anybody wants to leave, the mere fact that we have your name doesn't mean anything. Judges, of course, like lawyers, become frustrated with many aspects of what our profession is doing to itself. And I mention it to you young people, because I want you to think about it and hopefully help us do something about it. Other aspects of a judge's life sometimes add to these frustrations. Nevertheless, any frustrations on my part are to a great extent alleviated by those cases which were described by Justice Cardozo as being in the category where the colors don't match and the blocks don't fit. And I've had my share of those, and for which I'm grateful. And while it's not quite as exhilarating as a trial lawyer listening to the clerk read a jury verdict in his favor, wherein your viewers prevail, it is a reasonably good substitute. I premise my critique by an unabashed admission that I believe ours, as I've already told you, is one of the most exhilarating and contributing professions known to freedom-loving people. We live in a country where the people as individuals are paramount concern, and their rights and privileges granted under our Constitution and the laws to a great extent have been entrusted to trial lawyers. As the late Chief Justice Earl Warren said, trial lawyers have always been and are today the men and women. I must admit, I'm misquoting him. He forgot about the ladies when he made this statement, and I've added, and women, who preserve the basic principles of justice and keep alive those provisions of our Constitution and statutes which preserve and enlarge our freedoms. And while I believe ours is a great profession, there have been changes that have occurred in the past 20 years, and while perhaps in some instances are healthy and necessary, cause me great concern, and that forms the basis of my remarks today. In recent years, the courts have approved advertising by lawyers under the rubric of the First Amendment, and have struck down efforts to inhibit price competition by lawyers as violative of the Sherman Act, as Joan Button Goldfarb. I don't criticize those decisions. In fact, I was a participant in some of them. Nor do I expect or desire members of our profession to refrain from the now legal practices of advertising and engaging in price competition. What I do urge is that we proceed cautiously and with dignity, always keeping in mind the public service component of our profession in exercising those rights. I suggest that we have, in some instances, failed to police ourselves in the use of such practices, and the price we may pay, and indeed are now paying, is public rejection of the validity of our claim that our primary purpose is, as Pound suggested, the pursuit of a learned art in the spirit of a public service. Actually, my greatest concern about the effects of lawyer advertising and price competition arises from certain perceptions I believe have been created in the minds of the public. I am convinced that a large percentage of the public is beginning to perceive our profession as hucksters. The perception of huckstering encompasses not only a race to the scene, so to speak, but the use of the media to both solicit and in some instances to influence the outcome of litigation. Indeed, written solicitation has already occurred. And while I regret it, the regret is premised on my belief that it detracts from professionalism. Yet, admittedly, there was a survey by RAND disclosed that the majority of corporate officials felt it to be consistent with professional standards. Judges, so the survey indicated, felt it neither useful nor consistent with professional standards. Now, I want to make one more comment on advertising. I happen to have had the privilege of, not sure, Consumers Union was the name of the case, I believe, of writing a case involving the First Amendment rights of lawyers in advertising some months before Bates came out. And I know that's the law. And I have no complaint about that. And I have no complaint about that advertising that is done in a dignified manner. And I must say, I have not observed here, in this area, advertising that I think is undignified. But I have been in some areas of the country. I remember one spot made me ill, and I don't get ill easily. I was watching TV, and this character came shooting out of the water in a diving suit, and with this statement, "Are you in too deep?" See, Louis Jones, a bankruptcy lawyer, or some such thing. I didn't really get the end of it, because if it had been my TV, I'd have kicked it. But fortunately, I was in a hotel, and I thought, oh, the hell, it's not worth it. But I would have gotten, my frustrations would have been relieved a little had I been at home and could have done something. I also sense, and you haven't been subjected to this yet, but you will be if you don't guard against it, and if you don't choose the firms you go to carefully. I sense that certain segments of our profession, or at least of the business and judicial community, believe our profession is suffering, and I'm one of them, from an incurable condition known as the quest for billable hours. Over 75% of executives felt their attorneys perform unnecessary work to generate revenues. And a large majority of executives and judges believe lawyers place revenue considerations above the public interest. It has been rare that I have encountered that, but I have encountered it myself. My concern, however, is not with the factuality of the perceptions, though I believe there is some basis to it, but with the effect such perceptions have on public confidence in our profession and in our ability to render public service. I recognize that there is a view, and perhaps it's well-founded, that so-called huckstering, even if it occurs, is simply a part of the lawyer's obligation to zealously represent his or her client and to make legal services available. My own view, which is perhaps of little persuasion, is to the contrary. Many of it is for that purpose, but the majority, I'm afraid, is not. Many of the matters which I find disturbing about lawyer advertising are perfectly appropriate, as I've said, under the law, and perhaps that ought to be the end of my concern. I've told you, as a trial judge, I engaged in writing an opinions involving that. One was the Virginia Pharmacy Board versus Virginia Citizens Consumer Council case. It was a 3-judge court case. I don't recall that I wrote the opinion. I believe Judge Bryan Sr. Wrote it. But that was a beginning of the lawyer advertising cases, and it held unconstitutional the Virginia statute prohibiting price advertising concerning prescription drugs. That was a statute. I could have written the opinion in 2 sentences. This statute has been passed to protect the good old boys, which is true of a lot of statutes, not only here, but in other places. And it was violative of the First Amendment. That decision was based primarily on the consumer's right to know. And like Justice Holohan of the Arizona Supreme Court in the Bates state proceedings, my personal dislike of the concept of advertising by professionals gave way to my conclusion that the Supreme Court would conclude that consumers indeed have a right to know, and dignified advertising is helpful. And I don't discourage that. It's the other kind that disturbs me. I don't believe that, I do believe that few of the judges who were sitting on the Bates case in the Supreme Court and his progeny envisioned some of the advertisements that we see, a few of which have been forwarded to me by members of the public expressing repugnance. I've heard lawyers discuss what they view as bait and switch advertisement. I don't think we have any here, because we happen to have an exceptional bar in this area. But there's a contention that some members of the profession simply place ads and in effect act as brokers. When somebody calls, they say, oh, that involves a specialist, and I have a specialist on my staff in, I don't know, broken toes, I guess, or whatever it might be. And they switch. Now that is unprofessional, and I have no doubt about it. Well, I guess I ought not to talk too much more about advertising. I did mention the concern of billable hours and the billable hours syndrome. My concern is not with the difficulty of setting a reasonable fee, and I have that responsibility from time to time. That's part of my responsibility, and I've received extensive guidance from the courts, my superior courts, Hensley versus Eckert, City of Riverside, Johnson versus Georgia Highway. Nor is my concern that lawyers make too much money, because I don't think lawyers make too much money. My concern is more fundamental. I sense a tendency, hopefully overcome by the vast majority of the bar, to view billable hours as an end goal of the lawyer, rather than a means to the end of providing competent legal service to one's client. If the quest for the almighty billable hour becomes a paramount concern in the minds of young lawyers, then I have no doubt that the legal profession will suffer, and suffer tremendously. The ability of middle-income wage earners to secure sound advice is even now relegated to a hope and a prayer. Concomitant with the high billable hours is the fact that our profession's public service in the criminal law field and in civil rights have been described by some as infinitesimal. One commentator contends that approximately 1/3 of the bar fails to donate any time to pro bono services, and the annual average is less than 30 hours. I'm confident that one factor leading to high billable hours and large legal bills is an honest and sincere desire on the part of most attorneys to fully represent a client. And when I discuss this with lawyers, they tell me, and quite properly, the judge, they're looking over our shoulder. We are malpractice insurance and so forth, and everybody is looking over our shoulder. People, our own clients. Wait, if I ever had a client who I thought had in the back of mind to sue me, I'd have booted them out of the office so fast and incredible. I had clients who had confidence in me. And if they didn't, I told them to go elsewhere, because there were lots more out there. Now, that may be an honest and sincere desire on the part of lawyers, that is, to fully represent a client. Unfortunately, I think there are two other factors involved which are not quite as noble and are the cause of some concern. First, I sense a conscious belief on the part of many young lawyers that the higher-ups in their firms are looking over their shoulders and that they are being judged on their ability to accumulate billable hours. Firms set yearly, monthly, and even daily goals for their associates as to the minimum number of billable hours necessary to achieve success in their firms. And associates frequently feel competition between themselves to mount even higher totals. And while I certainly believe in the importance of hard work and devotion to the profession, I do not advocate the billable hours total as the ultimate test of one's worth to the legal profession or of one's contribution to lead to public service. I believe another factor leading to the billable hours syndrome is a belief on the part of some that more discovery is better because it means more billable hours. The rules of discovery were enacted as a vehicle to avoid trial by ambush and to achieve quick and effective justice. And while I believe the former goal has been accomplished, I have come to the reluctant conclusion that the latter has not. In my 20 years on the bench, I've seen discovery used as an effective tool for discovering truth and encouraging settlement. But I've also seen it abused as a means of delaying justice, coercing settlements, and unfortunately, I fear sometimes as a means of mounting billable hours. If there's any validity to my perception of this trend, it too is one which must be avoided and remedied by us, the members of the profession, before it is regulated from without. While we as lawyers and judges may focus on these underlying reasons for high billable hours and large fees, I fear the general public's concern centers solely on the fees themselves. The average citizen is shocked by fees ranging from $75 to $350 an hour, and more than that. I know of one case in which the lawyer got $1,750 per hour, and I know the case, and he earned it. He earned every penny of it. But the public doesn't understand it, and unfortunately there are many who believe, as I've said, that more discovery is better discovery. We're under attack, the profession is, and don't kid yourself that we're not. And you know, it's interesting because business did this to themselves, this damn billable hours, and I say that without hesitation. Because what they did, they said to the bar, itemize your bill. Now, I only had that happen once, and that was over 20 years ago. And an insurance company called me up, the vice president in charge of claims, and said, will you itemize your bill? I said, what do you mean itemize my bill? He said, well, I want to know how much time you spent on it and where you spent the time. I said, you can go you know where. I thought you hired me to win this case. As luck would have it, I had. He said, yes. I said, well, I did it. And if you don't think the bill is fair, don't pay it. His next statement to me was,